Missouri's newest gun law may be unconstitutional.
Missouri Governor Mike Parson is defending a controversial new Missouri gun law that's caused confusion among law enforcement.
The administration convinced lower courts that Missouri's Second Amendment Preservation Act violates the U.S. Constitution.
I mean, the red flag laws have never been in place in Missouri. You know, you're still talking about somebody with a mental illness.
I will protect the Constitution, which includes defending Missourians' fundamental rights to bear arms.
I've been a law-abiding citizen all my life. I am going to support people to have weapons that are law-abiding citizens.
The U.S. Supreme Court has just declined to resurrect Missouri's Second Amendment Preservation Act. They denied certiorari, which means they wouldn't even consider the case. The tally was 8-1, with only Justice Clarence Thomas objecting and seeking to take it up. Missouri's initial effort to prevent state and local officers from carrying out federal gun statutes is now essentially finished. But here's what nobody's talking about. Missouri isn't finished. Not even close. GOP legislators in Jefferson City are already advancing a fresh iteration of this statute. The battle over whether your state can shield your rights from federal intrusion is nowhere near settled. I'm going to lay out precisely what this means for you, where the original statute failed, and what to expect next. Governor Mike Parson is standing behind a divisive new Missouri gun measure that sparked uncertainty among law enforcement agencies. Missouri's latest firearms statute could be unconstitutional. America Tonight, bipartisan coalition of senators, announces they've struck a framework on gun reform legislation. The Supreme Court turned down Missouri's effort to restore its statute aimed at invalidating assorted federal gun constraints. Listen, I don't think anyone wanted to obstruct, or should obstruct, law enforcement from collaborating with federal or state agencies. Okay, let me explain why this matters to you personally, even if you don't reside in Missouri. This case, Missouri v. United States, represented the boldest attempt by any state in contemporary American history to nullify federal firearms rules inside its boundaries. Had the Supreme Court accepted this case and ruled in Missouri's favor, it would have unlocked the door for every conservative state nationwide to enact comparable legislation. Your state could have informed the ATF, informed the FBI, informed every federal agency that their gun rules don't apply inside state borders. That door has now been shut, at least temporarily. And if you're a firearm owner in Missouri specifically, you need to recognize that the $50,000 fine that would have been levied against any local officer who enforced federal gun statutes, that's over. Federal firearms enforcement in Missouri is completely restored. Agencies like the ATF can return to full coordination with state and local police without any risk of state-imposed sanctions. That's the situation today. So let me guide you through how we arrived here, because the procedural background on this one is vital, and it reveals exactly where the vulnerabilities lay. Missouri enacted the Second Amendment Preservation Act, referred to as SAPA, back in 2021. Then Governor Mike Parson, a Republican, put his signature on it at a Kansas City firearms retailer called Frontier Justice during that June. The statute itself was expansive. It proclaimed that nearly all federal actions, statutes, directives, regulations, and rules that encroach on the right to keep and bear arms would be deemed void inside Missouri's boundaries. We're talking about federal registration and monitoring mandates for firearms, attachments, and ammunition. We're talking about limitations on ownership by specific barred individuals. We're talking about any tax, assessment, charge, or stamp placed on firearms above ordinary sales tax. This department states that Missouri's new statute bars local authorities from carrying out federal gun statutes. Missouri police could be penalized for enforcing federal gun statutes that clash with Missouri law. Federal courts have determined that Missouri's Second Amendment Preservation Act breaches the U.S. Constitution. A group of 20 senators, split evenly across both parties, say they aim to have the measure passed at some point. The statute went beyond mere non-assistance. It levied a $50,000 civil penalty on any public official or state employee who willfully enforced these federal provisions. That's the element that distinguished this from a sanctuary city approach. Sanctuary cities merely refused to aid federal immigration enforcement. Missouri wasn't merely refusing to assist. It was actively penalizing anyone who collaborated with federal authorities on firearms issues. The Biden administration sued Missouri in 2022, contending the statute was unconstitutional. The case reached U.S. District Judge Brian Wimes, who ruled in 2023 that a SAPA violated the Supremacy Clause of the U.S. Constitution. That's Article 6 Clause 2, which establishes that federal law takes precedence when it directly conflicts with state law. Judge Wimes didn't hold back. He wrote that the Missouri statute was an unconstitutional breach of federal law and was, quote, designed to be precisely that. Missouri appealed to the U.S. Court of Appeals for the 8th Circuit, and the 8th Circuit backed the federal government, finding SAPA unconstitutional. Former Missouri Attorney General Andrew Bailey then petitioned the Supreme Court, not once but twice. The justices initially refused to step in back in 2023, keeping the statute blocked while the case proceeded. And now, on Monday, October 6, 2025, they denied certiorari once and for all, 8-1. A federal judge has ruled Missouri's Second Amendment Preservation Act unconstitutional. The Second Amendment Preservation Act is intended to block the federal government from these shootings in Columbia. That's blocking us from receiving the assistance we require at the federal level to stop all these local shootings. Hey, the Second Amendment Preservation Act was signed into law this weekend. He says it shields gun owners from overreach and executive orders. Here's what you need to grasp about the tangible harm this statute inflicted before it was overturned. The clash between SAPA and federal enforcement didn't merely generate a legal dilemma, it dismantled actual police operations in the field. The Missouri State Crime Lab refused to handle evidence that would have backed federal firearms prosecutions. Think about that for a moment. Violent crime cases, cases involving unlawful possession, cases that could have removed dangerous individuals from the streets, stalled because the state lab wouldn't touch evidence tied to federal gun charges. Coalition of Missouri law enforcement leaders publicly cautioned during the last legislative session that SAPA was, in their words, anti-law enforcement, and that it undermined their capacity to confiscate weapons from criminals. Kansas City and St. Louis both opposed the statute from the instant it was signed, and here's a detail that should give everyone pause. At least one of the weapons used in the 2024 Super Bowl shooting at Kansas City's Union Station was bought at the same firearms retailer where Governor Parson signed SAPA into law. Governor Mike Parson was standing on the far side of the stage Wednesday when shots erupted at the Chiefs' Super Bowl rally. These individuals, juvenile or not, need to face consequences. If you're going to do something like that, you need to be tried as an adult. But the reality is, you can't control people like that when they're determined to do harm. And I simply don't believe Missourians are going to go down the path of surrendering their firearms. Now, let me provide the wider constitutional backdrop, because this doesn't happen in isolation. The doctrine Missouri was leaning on is known as nullification, the notion that a state can declare a federal statute unconstitutional and refuse to acknowledge it. This theory traces all the way back to 1798, when Thomas Jefferson and James Madison composed the Kentucky and Virginia resolutions to oppose the Alien and Sedition Acts. But nullification has been dismissed by the courts repeatedly throughout American history. South Carolina attempted it in 1832 with the nullification crisis over federal tariffs. Southern states tried it again during the Civil Rights era to resist school integration. Every single time, the federal courts said no. Missouri's SAPA was the most refined modern attempt at nullification we've witnessed. But the legal result was completely foreseeable. This comes as the police department is suing his administration to overturn the Second Amendment Preservation Act. Police are suing now, clashing with Parson over their authority to enforce federal gun statutes here. Look, red flag laws have never existed in Missouri. We're still dealing with individuals who have mental health conditions. I've been a lawful citizen my entire life. I am prepared to back people who want to own firearms if they're law-abiding citizens. What matters is how this connects with the existing Second Amendment structure emerging from the Supreme Court in 2022. The court decided New York State Rifle and Pistol Association v. Bruin, which established that gun regulations must align with the historical tradition of firearms regulation in the United States. Then, in 2024, the court decided United States v. Rahimi, upholding the federal ban on firearms possession by individuals subject to domestic violence restraining orders. That was an 8-1 decision as well, with Chief Justice John Roberts writing for the majority that Second Amendment precedents were, quote, not meant to suggest a law frozen in time. Roberts stressed that courts must evaluate whether a new statute is sufficiently analogous to statutes that historical tradition permits. This is significant because SAPA specifically targeted the federal domestic violence prohibition as one of the statutes Missouri wouldn't enforce. The Supreme Court has now said twice, once in Rahimi, and now by refusing to hear Missouri v. United States, that these federal restrictions remain in force. She was going to come to your house, to your front door, and seize it. Well, not in Missouri. She isn't. I will defend the Constitution, and that means protecting Missourians' essential right to keep and bear arms. The Second Amendment Preservation Act is presently being challenged in court because some Missouri counties argue it's unconstitutional. There have been a handful of measures introduced by Democrats this legislative session calling for tighter gun statutes. So let me give you the straightforward evaluation. Is this a complete defeat for Second Amendment supporters? No, it isn't, but it's a major blow for anyone who believed state-level nullification was a workable approach for safeguarding your rights. The anti-commandeering doctrine, the principle that the federal government cannot compel state officials to enforce federal law, that still holds. The Supreme Court affirmed it in Prince v. United States back in 1997 and in Murphy v. NCAA in 2018. States absolutely can refuse to commit their resources to assist in enforcing federal regulations. What they cannot do is declare federal law void inside their boundaries and punish people for cooperating with federal authorities. That's where Missouri overstepped, and that's why every court that examined this said it was unconstitutional. Now here's what's on the horizon, and this is what you need to monitor. Republican Representative Bill Hardwick from Dixon, Missouri, has been championing a revised version of this legislation. The particulars of the updated measure are still being hammered out, but the objective is to craft something that stays within the bounds of the anti-commandeering doctrine without venturing into nullification territory. Consider it SAPA 2.0, a statute that says Missouri will not voluntarily assist with federal firearms enforcement, doesn't impose penalties on officers, and doesn't declare federal law invalid. Whether that version can withstand judicial scrutiny depends entirely on how meticulously it's drafted. The Trump administration, interestingly, took a divided stance on this case. They defended the prior administration's authority to sue Missouri initially, maintaining that the federal government can challenge states that claim to invalidate federal statutes. But they also indicated they no longer wished to challenge Missouri's law before it was applied in an actual dispute and proposed narrowing the lower court ruling. That's an indication that the current DOJ may not vigorously oppose a more carefully crafted version. Here's your current status check. Missouri's original SAPA is dead. Federal firearms statutes are fully enforceable in Missouri with state and local cooperation. The $50,000 penalty against officers is gone. If you're a firearm owner in Missouri, nothing changes regarding on what you can legally own or possess. This was always about enforcement structures, not your individual rights. But keep your attention on Jefferson City. A new measure is coming, and depending on how it's written, could reshape how your state engages with federal gun enforcement moving forward. I'll cover it the moment we have bill text. That's it for today, folks. See you in the next video.